Hello and welcome everyone to Al-Tamimi and Company's webinar on the impact of coronavirus and how Oman has responded to the pandemic. My name is Ahmed Al-Bawani and I'm the head of the Al-Tamimi office in Oman. I am joined today by my colleague Richard Baxter, who is a senior corporate commercial lawyer in the Oman team. Over the past 6 months, the global market has experienced unprecedented times, which has impacted GCC region and locally the Oman market. Today, we are going to cover mainly 3 topics. The first topic is regarding Oman's new bankruptcy law, its objectives, and what it could mean for you. Secondly, we are going to cover the force majeure and emergency circumstances under Oman law, along with the legal consequences and implications. And thirdly, we are going to cover and provide a brief summary of labor law issues and what can be implemented during this time. At the end of the session, we will have time for Q&A. If you have any questions you would like to pose to us, please type them in the questions tab on the right-hand side of your screen, and we will try to answer as many of these as possible later on. Without further ado, I will hand over to Richard, who will kick off with the new bankruptcy law.
Thank you, Ahmed. Good morning, ladies and gentlemen, and thank you for joining us. I hope you are all safe and well in these difficult times with the pandemic. With the new bankruptcy law in Oman coming into force on the 7th of July, we felt it may be helpful to include this analysis in this webinar on impact and responses to the COVID-19 epidemic, given the pandemic has clearly caused differing levels of financial distress to businesses both globally and in the region. So although the new bankruptcy law was promulgated last year to come into force on the 7th of July, so it's not really a direct response to the COVID-19 epidemic, we felt it was clearly relevant and may well be on a number of clients' and contacts' minds at this time. While the bankruptcy law may appear to be a negative topic in the current economic climate, the new law should, in our opinion, be viewed as a positive development for both debtors and creditors. Distressed debtors may be able to use the other measures in the new law, other than bankruptcy, a formal bankruptcy process, to avoid bankruptcy and maybe trade out of difficulties, potentially retaining a degree of control over their assets and business, albeit possibly under some form of supervision. Creditors, particularly unsecured creditors, may well make better recoveries where a bankruptcy is avoided. Any steps towards a business rescue culture and a clearer legislative framework for insolvencies should improve economic performance, save jobs, and increase investor confidence. As the legislation is, of course, untested to date, we shall keep the review high level. Please do submit any questions via the online facility that Ahmed has pointed out earlier. And if we run out of time, please also contact either Ahmed or me by email after the webinar. Moving on to my next slide. We will look at the various, sorry, if we can go back one slide, maybe got one slide ahead of myself, that's great. So looking at the various procedures and processes available under the new law that are available to distressed businesses, and then I'll move on to rehabilitation of bankrupts. So the processes are broadly restructuring, preventative composition, or bankruptcy, judicial composition really being a subset of the bankruptcy process, which can be implemented during a formal bankruptcy as an alternative. So I'll be focusing predominantly, I think will be of most interest on the restructuring and preventative composition elements, and move fairly quickly over the bankruptcy provisions, which are fairly formal and are about gathering in the bankrupt's property and then making distributions to creditors in the order of priorities that tend to exist in bankruptcies and do under the new law. As stated previously, it's probably broadly best for all parties if bankruptcy can be avoided. And it's probably usually more used as a negotiating lever for creditors, where better recoveries may be realised by striking a compromise with the debtor. In that regard, we would recommend our chairman and founder's article, Hassan Al-Tamimi's article on our website, as to 10 reasons you should not consider filing for bankruptcy. While this addresses the UAE legislation, it highlights many of the issues pertinent to the Oman position, the first 8 of the 10 issues highlighted in that article, including loss of a going concern and jobs. There's no way back once the bankruptcy process is commenced, although the judicial composition may be a slight exception to that rule. Limited recovery for creditors, often, especially unsecured creditors under a bankruptcy process. Loss of control for the debtor of both the business and the process. Full disclosure and lack of privacy, many newspaper announcements, and although obviously there's an effort to destigmatize bankruptcy, it may carry reputational risk for the debtor. Time pressures with short legislative timeframes, risks to officers who can be liable if there's been any form of misfeasance or recklessness leading up to the bankruptcy, and the preference for secured debtors, meaning that often unsecured creditors will find nothing relevant for them pursuant to a bankruptcy process. Quoting from the article, although the UAE context again relevant in the Oman context, Hassan Al-Tamimi has commented, no lawyer or financial advisor will disagree that if a business engages in a full and formal bankruptcy process, then ultimately there is a high chance that the business will end up in the graveyard. If a company is declared bankrupt, significant legal, commercial and economic repercussions will follow. It will likely lose all of its cash and other assets, while its creditors are unlikely to get back all their debts. A merchant who applies for bankruptcy is unlikely to be in a position to manage a business or be on a board of any corporation for many years. The bankruptcy process is a legitimate legal process designed by the legislator and recognised under the law, which is available to, firstly, businesses which are unable to pay their creditors, or secondly, in certain circumstances, to the creditors of such businesses who don't receive payment they are due. However, there are many reasons why the bankruptcy route should only be considered where a business has exhausted all possible alternatives. So returning to the slide, you'll see that the scope of the law excludes banks and insurance companies, but is applicable to all other traders as defined in the Commercial Code as being any person engaged in commercial activities. Article 5 of the new law provides for a roster of experts to be drawn up who are able to assist clients, debtors and creditors with these processes. And there's currently some uncertainty as to who will be on that roster, but we imagine it will be broadly the accountancy and maybe legal firms here in Oman. Moving on to the next slide, we look at restructuring and reorganization. This is mainly on the slide, the content that we would draw your attention to. It's a consensual compromise between the debtors and the creditors. The aim is to avoid liquidation and assist debtors to trade out of difficulties. The debtor applies for the petition, but there must not have been any evidence of fraud and subject to the debtor having traded for at least 2 years. The debtor will have to show the hardship that is leading to their inability to pay their debts as they arise. But hardship is not defined in the new legislation. But the application must be made within 6 months of such hardship arising. I'll make a comment later on hardship because in other jurisdictions who maybe have longer running insolvency legislation on their books. There's quite a raft of case law about how hardship may have arisen and responsibility of officers and debtors in that hardship arising, whether they've been reckless to that or there's been any misfeasance in their handling of the business. So that will be a developing area that we'll be keeping our eye on as this legislation comes into force and is litigated or brought before the relevant authorities. The application is considered by a committee of experts who develop a restructuring plan, taking into account reasons for the hardship having arisen. The plan needs to be implemented within 5 years of being agreed, and the Ministry of Commerce and Industry mediates between the debtor and the creditors. If parties agree, the matter is referred to the court for approval, and once it's received the court's approval, it's then binding on the parties, and that restructuring plan will be in force. It requires unanimous creditor consent, so it's a high bar to pass. All creditors are going to have to be satisfied. Some issues that are not on the slide that may be of interest is that Article 8 sets out the material that needs to support the application. Article 9 guarantees confidentiality is maintained. So this is a process that may well be attractive to debtors because it is confidential up to the point that the restructuring agreement is made public. There is a process for appeals if the application is rejected. The court may appoint an associate to oversee the restructuring plan, and the court will determine the fees for that associate. The debtor continues to manage his business and own property during the implementation phase, subject to Article 19, which clearly stipulates that that must be at all times protecting creditor interests. Once the plan has secured court approval, there's no further proceedings viable between the signatories to the plan while it's being implemented, unless, of course, there's been some form of dishonesty or misleading the court in the setting up of the plan. And it ends once the plan is once fully completed and the creditors are repaid. The process then ends and the court then withdraws, unless the debtor can achieve a quicker repayment of all creditors within the time frame set out in the plan. So if it's quicker, it will terminate more quickly. The advantages, as you can see on the right, are pretty clear. It can rescue jobs and possibly deliver a better return for creditors in the long run and rescue the business potentially. And owners remain involved with the assistance of experts to try and deleverage the balance sheet. Moving on to the next slide, we can look at the alternative remedy under the new law, which is the Preventative Composition. Again, this is a trader debtor motion or application. And again, there must be no evidence of fraud on the part of the debtor, and the debtor must have traded for 2 years, but here also they must not be grossly at fault. This is not a process which is available to joint venture entities, and it should be noted, and I mentioned later on, that if a unincorporated joint venture partner becomes insolvent or bankrupt, the other partners to that unincorporated joint venture will be deemed insolvent and bankrupt also. So that should be considered carefully if anyone is considering an unincorporated joint venture in Oman. Hardship is, again, as I say, not clearly defined. It's the inability or imminent inability to repay debts as they arise, and the court may investigate the circumstances under which this unfortunate situation has arisen for the debtor, and that may influence the court's willingness to grant a preventative composition or bless one. The process requires majority creditor consent by number and 2/3 majority consent by value of the amount owing from the debtor. The preventative composition will impose a comprehensive stay on all proceedings, bankruptcy proceedings, debt claims and execution claims. The court will appoint a trustee who will supervise the debtor, who can then retain and preserve assets if the preventative composition is agreed and put into place. Some areas of interest under the preventative composition which are not on the slide is that under Article 30 of the new law, the court may order interim measures in respect of the applicant's property, that's the debtor's property. There's a fine if a application is made and it's not granted between 500 and 1,000 riyals. Once the preventative composition is agreed by the court, when the application is submitted to the court, a judge will be assigned and trustees of composition appointed. Once agreed, there'll be publication in daily newspapers. The debtor is still involved under this process in the management, albeit under the supervision of the composition trustee. And also, no fourth degree family members can participate in these kind of processes, obviously to stop dissipation of assets or diversion to family members away from creditors. In-kind security holders may need to waive their in-kind security in order to participate in a preventative composition process. Once endorsed, it will be published in the official gazette in Oman, so there will be publicity there. It's enforceable against all creditors other than those collateralized by lien or mortgage. And the arrangements can be set aside if it's found that the debtor has been delinquent or there's proof of fraud on the debtor's part in securing the preventative composition. Turning to the next slide and moving on to, as I say, a very high-level review of the new bankruptcy provisions. You can see that on the slide that this is a process that's allowed for if following 15 days of cessation of payments, the debtor can apply, or this can also be applied for by a creditor or of the court's own motion, I would say, or the court can implement the idea that a bankruptcy should occur. The court may order precautionary measures against funds of the debtor and its management, and that's renewable for further periods, and the court will keep the debtor's financial position under review. If a bankruptcy order is made, a liquidator is appointed and the matter will be made public in the official gazette again. Creditors are then invited to submit claims, and if proven, they will participate, but often, as we say, the secured creditors will really be the only beneficiaries of many bankruptcies. And if the bankruptcy order is made, it results in no further claims save for sale of assets by secured creditors. Matters not on the slide again that may be of interest. Chapter 1 of the section on bankruptcy in the new legislation again sets out the supporting material required for an application for bankruptcy at Article 71. Chapter 2 sets out the effect of adjudication of bankruptcy on creditors and third parties, whereby there will no longer be the possibility of individual lawsuits against the debtor bankrupt at that point in time. Mortgages can be paid by the trustee and property included in the bankrupt estate for distribution. Priorities are always an issue. Only the government really rank above the secured creditors, and then immediately after the secured creditors will be wages and salaries and amounts due to employees, although not the compensatory payments that might be expected on terminations of employees, just their contractual dues. Lessors of the business property, if the trustee wants to carry on the business property, will be entitled to the previous year's rent and the current year rent, and guarantees in respect of the current year rent. The tax authorities will be looking for the previous 2 years' tax, liens over movable property are a moot area in Oman, where floating charges are not generally recognised. Third-party contracts tend to continue if they're viable, so the obligations there will continue. Clauses and stipulations in leases and rent agreements for accelerated payment of rent or no termination will be voided in a bankruptcy process. And I think that's probably the key points under bankruptcy. As I say, it's a high-level review. It's a fairly extensive section of the new law, but it will be dealt with really mainly by the advisors advising at the time of bankruptcy. We're happy to take any specific questions rather than go through the rather terse provisions of valuing, gathering in and distributing. So turning to the next slide, and my penultimate slide, before I hand back over to Ahmed. Judicial composition, we won't, this is during a bankruptcy process. The court can of its own motion suggest a judicial composition. It's really a mediation process instigated by a bankruptcy judge on request of an interested party. The court secretariat invites proven creditors to attend the deliberation, and a liquidator or trustee of the creditors union submits a report as to the state of bankruptcy and proposals for a judicial composition, viable if a majority of admitted creditors holding 2/3 of the debt value agree. If endorsed, a judgment is issued and all bankruptcy measures cease, with a closing account to be discussed with the judge in the case. Moving on to my final slide, looking at rehabilitation liability and our final comments. Absent any fraud or recklessness on behalf of the bankrupt, if all debts and expenses are paid, all debtors' rights are restored at the time that all debts and expenses are paid. Otherwise, after 3 years from the end of the process, an application can be made by a bankrupt to be rehabilitated. I mentioned earlier Article 192 of the new bankruptcy law that joint venture partners to an unincorporated joint venture should be cautious, because bankruptcy of one partner will imply the bankruptcy of all partners, including those who've retired within the 12 months prior to the bankruptcy. Penalties set out in the new bankruptcy law range between 500 to 5,000 Omani rials. But frauds and deceptions during any of these processes are subject to the penal code and terms of imprisonment provided for in the penal code, and also within the new bankruptcy law, terms of imprisonment up to 3 years for deceit or misleading in proceedings and compromises. So that's really a fairly swift tour through a fairly bulky piece of legislation, but as I said, I think it gives a feeling for what's there. Our conclusion, you can see there on the final slide, is that clear creditors' rights and options for a rescue culture for distressed businesses are helpful features of any codified commercial landscape. and the new law should increase investor confidence and assist Oman as it continues to diversify and develop its economy. So that's everything from me on the new bankruptcy law. I hope that's helpful. I'm very happy to take questions at the end, but for now, I'll hand over to Ahmed to take us through force majeure.
Well, thank you, Richard. Very much. Force majeure has attracted a lot of discussion recently because it means either suspension of obligation or complete release of obligations of the contractor or the debtor. And starting with the first slide of the force majeure, the definition of a force majeure. The force majeure is widely known as act of God, although there is no specific definition under Oman law. Most contracts define force majeure as an event that's beyond the control of the contracting parties. And some contracts also include an exhaustive list of force majeure events. Such clauses commonly include the term epidemic, which will most likely qualify and encompass the coronavirus COVID-19 outbreak as a force majeure event. Whether the coronavirus outbreak qualifies as a force majeure event significantly depends on the force majeure clause stipulated in the contract and how it is worded. On the other hand, and in comparison to the force majeure, emergency circumstances is defined as an event which arises during the course of the contract and it's not attributed to any of the contracting parties, and which makes the performance of the contract burdensome, albeit the fact that it's not impossible. Emergency circumstances, unlike in the event of impossible performance, don't result in an immediate lapse of termination of the party's obligation. In order to classify an event as emergency circumstances, it must satisfy three conditions under the civil law. Firstly, that the emergency circumstances don't render the performance of the contract impossible, but rather burdensome on the debtor or the contractor as a result of such factors. And secondly, the fact that the emergency circumstances which occurred couldn't be foreseen or avoided by the debtor or the contractor. So both parties that would not foresee that such events may occur. COVID-19 is something which is not expected by the parties to the contracts in Oman, and therefore it may give rise and satisfy this condition. And thirdly, such emergency circumstances are deemed exceptional factors which shall affect the contractor or the debtor among others and shall not be required to have the same effect on all debtors affected by such circumstances. In relation to the provisions under Oman law, as a general rule set out in Article 159 of the Civil Transaction Code, if general exceptional circumstances occur which couldn't be avoided during the contracting period, and as a result of its occurrence, the performance of the contractual obligations, including the payment of rent by way of an example, become impossible for the debtor, which may cause substantial loss, the court, following the assessment of both parties, may reduce the burdensome obligation to a reasonable level, and in any agreement otherwise should be considered void. Further, Article 172 of the Civil Transaction Code goes beyond that and considers the contract automatically repudiated by itself. If the contracts, as it states in Article 172, if the contracts binding on both parties, if force majeure occurrence makes the performance of the contract impossible, the corresponding obligation shall cease and the contract shall be automatically terminated. In the case of partial impossibility, that part of the contract which is impossible shall be extinguished, and the same shall apply to temporary impossibility in continuing contracts. And in those two cases, the creditor may terminate the contract provided that the debtor is notified. And we'll see that in most contracts, actually, there is a requirement of notification to be made by the debtor. Moving to the second slide, regarding the legal consequences and implications, the civil law in Oman deems a contract to be terminated when force majeure or circumstances occur, provided that such circumstances render the execution of the contract impossible, and such impossibility to perform is not attributed to the parties of the contract. So that means it goes beyond the control of the parties. In the event of occurrence of temporary circumstances which render the execution of the contract impossible to perform temporarily, the contract shall not be considered to be terminated. However, the obligations will be suspended until the foregoing circumstances have been resolved or are ceased or interrupted. Build to lease contracts is a classic example which a lot of clients, or number of clients, have been approaching us for some advice for the applications of the force majeure and emergency circumstances. In those contracts, generally, we have come across contractual provisions where expressly stated when the contract could be terminated or suspended for a number of grounds or reasons that can be either classified as a force majeure or emergency circumstances. Most of the contractual provisions are linked with a period of time. By way of an example, in the event occurs continuously if the event occurs continuously for 6 months, then this may qualify as a force majeure rather than the emergency circumstances, which can be classified if it continues only for any period less than 6 months, by way of an example. The pandemic of COVID-19 is likely to give rise to emergency circumstances in such contracts rather than the force majeure. And as a result, the tenant or the debtor may request reduction of rent or the consideration to be paid to the creditors, as the case may be. Nonetheless, the tenant is generally expected to notify the landlord or the project owner regarding the occurrence of the pandemic or any event in order to qualify for the suspension of obligation or termination of the contract in the future. Regarding the provisions under Oman law, which can be relevant to the legal consequences and applications, we would like to highlight Article 523 and Article 550. The consideration or the lend is only entitled upon conditional on the satisfaction and utilization of the benefit, which is currently not taking place. So if there is no benefit at all to be utilized, then the application of 523 and 550 would be applicable here. As further assurance to this, if the utilization or benefit of the leased property cannot be achieved, the rent should be waived during such period. Moving to the third slide, which I'll try to keep it short here, because we have already highlighted those provisions as continuation on the application of Article 523 and 550. The freeze on the commercial activities by the decisions of the Supreme Committee and subsequent implementation by the authorities in Oman. This has led to either reduction or non-payment of rent or termination of the contract. So the Supreme Committee decisions are of importance to be looked at when deciding about the reduction or non-payment of rent. And we understand that the Oman courts will look at this as important elements when they consider any cases in the future. This is only applicable to some commercial activities that have been subject to the committee's decision, but not any other activities like pharmacies, hospitals, and warehouses. So some of these activities have been ongoing and they haven't been subject to any freeze by the Supreme Committee decisions. Moving to the fourth slide, regarding the time of claim. Most of the contracts in Oman, if they are between two companies or traders registered, will be classified as commercial claim. And generally, commercial claims are looked at by the commercial courts here in Oman, and the type of supporting documents that will be required to be presented to the court, given that it has jurisdiction according to the governing law and the jurisdiction clause, will be any contractual documents that have been concluded between the parties, the decisions of the Supreme Committee, or any communications with the authorities, and the notifications, as we have mentioned, to the project owner or the engineer, depending on the type of the contract, and the correspondence and any other underlying documents relating to the case, as the case might be. The limitation period for the obligations of merchants or traders towards each other in relation to their commercial activities shall be 10 years as from the date of the performance of such obligations lapses. In relation to the jurisdiction of the court, generally Oman courts will assume jurisdictions of the contract is executed here in Oman. Otherwise, if there is an arbitration clause and either party argue that the Oman courts doesn't have jurisdictions because of the arbitration clause existence, then Oman courts will not assume jurisdictions. Again, if there is any jurisdictions for foreign courts, Oman courts may not look at it, or they can assume and apply the foreign law. Moving to the fifth slide regarding the consideration to be taken by the court and the assessments of the claims generally, the most remarkable prerequisite is that the force majeure event must be unforeseeable in order for it to be classified as a force majeure. If either of the parties to the contract, or both actually, was in a position to anticipate or presume that the force majeure event, there will be no room to have a recourse to the force majeure principle if they have a knowledge or they know about it before it occurs. The analogy behind this is clear, as each party to the contract is under an obligation to act in good faith and to mitigate damages if foreseeable. If the defaulted party fails to exert its best effort to mitigate the effects of the underlying event leading to the force majeure, that party will be consequently precluded from invoking force majeure to get executed and released from the performance. Further, the underlying event must be unavoidable and beyond the defaulting party's control in order to be regarded as a force majeure event. So all of these elements have to be considered and established before the court. Once an event meets the aforesaid requirements, the contract is deemed rescinded by statement of law, and the parties revert to their pre-contractual position, and if possible, damages are to be awarded to restore parties' positions. Generally, the court interprets the force majeure clauses in Oman very narrowly, where courts frequently mandated that the underlying events must make performance of the contract impossible, unforeseeable, or uncontrollable. The reason behind that is the consequences of the application of the force majeure as the defaulting party are executed and released from the performance. The court will also take the Supreme Committee's decisions into consideration when assessing any force majeure or emergency circumstances events. In relation to the assessment of compensation and damages, the general rule under Oman law is that the court award for the actual losses and profits to be made only by the party for which the judgment is issued. Indirect damages is remotely or unlikely to be applied or awarded by the courts. However, it cannot be excluded totally, and this will depend on how the clause is phrased in certain contracts. The judgment, if issued by the Oman courts, it will be enforced by the execution department through opening of an execution file here in Oman. If there is a foreign arbitral award or foreign judgment is issued from outside Oman, if there is a foreign law which is applicable here, then the execution case will need to be filed with the Oman courts in order to start the enforcement proceedings. It is anticipated that the force majeure claim will be on the rise over the coming months due to the COVID-19. However, as the World Health Organization declared that the threat of coronavirus, since it was first reported from Wuhan in China, on 30 December 2019, any defaulting party to a contract that's concluded afterwards is unlikely to succeed in invoking the force majeure, because then both parties will know about such claims. As for the contracts preceding the WHO declaration, it will be examined on a case-by-case basis in order to determine whether the underlying events meet the criteria set out by the law or not. That's all regarding the force majeure and the emergency circumstances for me. And I will hand it again over to Richard in order to cover and give a brief summary on the labor law issues.
Thank you, Oman. Thank you very much. Sounds like an area ripe for some dispute, and plenty of advice will be required by clients. Thank you for that very informative summary. Just a very, very swift whistle-stop tour. I'm sure employment law matters have been of interest to a number of clients and contacts over this period. So just looking at the slide on employment law, the next slide, I'm sure that everyone's aware by this stage that the key measures were introduced by the Supreme Committee to deal with the COVID-19 epidemic on the 15th of April 2020, measures in respect of private sector firms and establishments that are affected by the pandemic, which is probably the rump of all private sector establishments, I would have thought, on the whole. I picked up just a few of the key provisions there. There were a wider set of provisions, which I'm sure people have seen. For instance, the ability to delay the payment of PARSI, etc., payments to the Public Authority for Social Insurance, and pay those later, delay payments. But I think these were the key ones. The ability to offer advance paid leave to the workers of private sector firms and establishments that have been affected by the pandemic. Those firms that have been affected may also negotiate to lower the salaries of their workers and employees for a period of 3 months, May, June and July, in return for a proportionate reduction of duty hours. It should be noted there that Omani employees' salaries should not drop below the national minimum wage of 325 Omani riyals per month. Expatriate workers of affected firms can be terminally repatriated to their respective countries. That may, of course, have been an issue over the period while airports have been closed and borders have been closed. According to the package agreed by the Supreme Committee and establishments and firms of the private sector. And finally, the private sector firms may terminate their expat workforce's labour contracts and provide that these institutions commit to paying all workers' dues before leaving the country permanently, which is, of course, a departure from the previous position, whereby if terminations were not on an Article 40 ground akin to gross misconduct, then terminated employees would have been entitled to a minimum of 3 months gross salary as a compensatory payment. The only comments we really wanted to make here were for clients and contacts to maybe exercise some caution, possibly take some advice, because the right to terminate expatriates should be exercised cautiously where there is a degree of uncertainty, although Ahmed may have more intelligence on that now as to how the decision of the Supreme Committee may subsequently be viewed by courts if any employee did bring a complaint that they were entitled to a compensatory payment, or that maybe the impact on the business didn't justify the termination of an expatriate, although it would seem to render the decision of the Supreme Committee somewhat meaningless unless the courts were going to interpret it as a right to terminate that compensatory payment. And then just when negotiating the lowering of salaries with proportionate reduction in working hours, it should be noted that that was stated as a right to negotiate. So again, some portion should probably be exercised not to offend or disgruntle employees too much, as there may be some kind of viable claim there if it's been believed that it's been exercised unreasonably. So they were the only real comments on employment law, but happy to field any further questions that you may have. And I believe that now concludes Ahmed's and my presentations, and we will move on to the Q&A. And I think our colleague Kelly will be able to call out some of the questions that may have been raised, and we'd be happy to field those. Are you there, Kelly?
Hi, Richard. Hi, Ahmed. Yes, we have a couple of questions. Just a call out to all the attendees. If you do have any questions to ask, please pop them in the questions box on the right-hand side. Perhaps we'll go to Ahmed for the first question. The question from the audience is, there is a thin line between the impossible and possible, but at a loss to the contractor. Where does the law cut this off? Ahmed, I think you mentioned it's probably on a case-by-case basis, but I just wondered if you had any comments on this.
The distinction between where the court draws the line between possible and impossible, that's maybe a blurred line in some circumstances.
Yeah, indeed. I mean, the distinction between the possible and the impossible would largely depend on the factual situation and how the contract is worded. Generally, they would look at the provisions of the civil law, and they would determine, according to the criteria set therein, if this would qualify as possible or impossible. And the criteria we have highlighted in the presentation would give rise to a force majeure or emergency circumstances. And if it gives to the emergency circumstances or it qualifies as emergency circumstances event, it would give the right to suspend the obligation. And if it qualifies as a force majeure, then it will lead to termination of the contract. In a sense, it is a factual situation that needs to be looked at by and determined by the court.
Thank you, Ahmed. One more question for you actually on force majeure. If the Oman government makes any changes to legislation, will this be classed as force majeure?
Yeah, this is what is referred to as a legal impossibility, and legal impossibility qualifies as a force majeure. So yes, it will be qualified as a force majeure. However, the Supreme Committee decisions will need to be looked at if they are considered to be change of law or not.
And another one for you on force majeure, please. To what extent are the decisions of the Supreme Committee enforceable?
The Supreme Committee are made by way of royal orders, and their decisions have been published, and therefore it is more likely that they will be enforceable and recognized by the courts. However, they haven't been published in the official gazette in order to become a law. So this is an area, again, if raised by the court, then the court would say its opinion regarding the publication in the official gazette. In our view, it is likely to be recognized and enforced by the courts as a decisions.
Okay, great. A question for you, please, Richard, on the employment matters. How does a business prove it has been affected by COVID?
That's a good question. It's obviously yet to be tested, but I think reference to its accounts and ledgers, obviously it's going to be difficult to have filed accounts or audited accounts for the period probably in question. So it'll be a question of looking at the management accounts, I imagine, and see the downturn in business that's been occasioned, obviously for some businesses such as cinema operators and some of the retail outlets that have been completely closed, it's going to be pretty clear that they've not had any revenue at all. Whereas downturn in business for other types of business will be more readily evidenced by their books.
Thank you. One more question from the audience. Consequences of the COVID pandemic are unclear. When tendering under this threat right now for future contracts, does the law allow for their revision?
Does the law allow for revision if you're tendering now for business on the basis that this will have ended? Yes, then it continues. Then I think it's a matter of contractual.
Yeah, I mean it's a matter of contractual provisions, and they can think of some relevant provisions here, like extension of time or period for the tenders themselves. So I think this will be taken into consideration, and they will have, yes, an impact on the future contracts. So instead of having, by way of example, a month for establishment of a company, which is one of the tendering requirements under Oman law, it may extend to 3 months or 5 months, given that some of the authorities in Oman actually haven't started working, or they work with less capacity, about 50% currently.
Thank you. Another question for you here, Richard. If an employee has filed a case against termination under the Supreme Committee decision, will the company need to prove it's been affected by COVID to the court?
Sorry, I just didn't catch the end of that, Kelly. So yeah, if an employee has been terminated pursuant to the Supreme Committee decision, what was the last bit, sorry?
Will the company need to prove it has been affected by COVID to the court?
I think so. That would be my opinion, and I've spoken to some other employment lawyers here in Oman. So I think it does need to be evidenced. The terms of the Supreme Committee decision is that this is justifiable on the grounds that the business has been impacted negatively by the epidemic, or the pandemic, I should say. So yes, I believe that that will need to be evidenced if they want to meet that complaint or claim of the employee and defeat it. Then they will need to evidence that they have been negatively impacted by the pandemic.
If I add one point here, otherwise there is potentially that the termination could be considered to be wrongful if it is outside the decisions of the committee, because it would not be classified as any grounds under Article 40.
Yes. And I think time for one last question. Same person posing this question. If there are, say, 8 employees at the same level, will the company need to explain why certain individuals were terminated as opposed to others?
That's a good question. It's probably something that's not really clear as yet, because this hasn't been tested before the courts. There's no specific obligations in normal times to evidence fair handling of dismissals, but one would expect that that would support any employer's case if they had decided to make redundancies at a level where there were comparative staff. So one would generally want to show that one was acting on a last in, first out basis, or that performance grounds meant that there had been a selection. But really, in normal times in Oman, the only real grounds for non-arbitrary dismissal are the Article 40 grounds. If you're even dismissing on performance basis in normal times, then you would be looking at making compensatory payment for arbitrary dismissal, unless it was an Article 40 ground. So I would be armed, best practice would be armed with evidence as to why a decision has been made to select certain staff rather than others, all other things being equal.
Thank you both. I will leave you now to wrap up the session.
Thank you. Just a few words from me before Ahmed maybe says the final words. Thank you all for attending. I hope it was helpful. Do please reach out to us on our email addresses there if there's any further questions that occur or any other issues that we can help with. And once again, thank you for attending. I hope it was helpful.
Yeah, one word from me. I would like as well to take this opportunity and thank you for joining us to this webinar. And we look forward actually to organize more webinars in the future, as we expect the Oman government will be issuing more laws following, of course, the COVID-19, and therefore that type of laws will need to be covered separately, like the bankruptcy law, which has been covered by my colleagues, Richard Baxter. Again, thank you, and hopefully to meet you soon, and hope you stay safe. Thank you.